We're going to get started. Thank you very much for coming to day 2 of our 5th annual Watershed Conference. Glad those people can join us both virtually and in person. And I appreciate you all being guinea pigs, so to speak, on this experiment. This is, I think, the first time anyone's really tried this experiment of both hybrid, virtual and in person. So I said, good morning. Welcome to Important Court Cases and Regulations. I'm going to start off with a land acknowledgement and then we'll get started. We'd like to start with a land acknowledgement. We recognize that the land and water now under our care is the traditional and ancestral territory of the Lenape. We pay respect to the Lenape peoples, past, present, and future, and their continuing presence in the homeland and throughout the Lenape diaspora. We respect their knowledge, culture, and traditions, which have contributed to the conservation of land and water. We also acknowledge that historic white supremacy and environmental racism practices have caused disproportionate environmental and climate impacts on people of color and overburdened communities. The Watershed Institute pledges to work for clean water and a healthy environment, including in communities that have been unequally affected by systemic racism and environmental pollution. I'd also like to thank our sponsors. We have the Dodge Institute has been funding our programs for a number of years, and this conference, Princeton Hydro, Lake Hopatcong Foundation, and Musconetcong Watershed Association. Just one or two housekeeping things. My plan is I'm going to introduce our speaker in a second. She's going to start. We're going to have a very short question and answer period, and then I will present some state level issues, and then we'll have a much larger question and answer. If you have questions, please put them in the chat if you are virtual. I'm going to ask people who do put questions in the chat to come up on the screen if they want to ask those questions in person, so to speak. And obviously, if you are in person, we can ask questions. I will also send out a poll once or twice during this presentation. If you are an attorney and are seeking CLE credits, we're in the process of applying. We've submitted some of the material and we'll be submitting the rest at the end of this conference, hopefully to get CLE credits. So please respond to that poll. If you're not an attorney, you can ignore it. So with those sort of housekeeping things, I'd like to introduce Jennifer Danis. She's the Senior Fellow for the Sabin Center for Climate Change Law at the Columbia Law School and Columbia Climate School. Her full bio is in the materials, but I would say Jennifer Danis has been, and she'll talk about the PennEast Pipeline, sort of the legal mastermind and really just the strategist on getting us to where we were with that fight. She is obviously an attorney, and I'm gonna hand it over to Jennifer so we can all learn.
Good morning, everyone. I thought that I would start with some Clean Water Act cases and then move on to some pipeline cases. And finally, just very briefly, touch on the Supreme Court's move to take up some pretty important questions from Clean Air Act cases that happened just last Friday. So I'm going to start with the Waters of the US rule. And the Waters of the US rule is something that has been really tossed and turned around in the courts. And at its most basic level, the Clean Water Act forbids any addition of pollutants from point sources to navigable waters. So that sounds really straightforward. The Waters of the US rule is kind of the controversy that's come up around how we define jurisdictional navigable waters. And some of the other cases we'll be discussing actually involve the word from, which seems like a very common sense word. But the question in that suite of cases is, what does it mean to add a pollutant from a point source to navigable waters? So we'll turn to that controversy in a minute.
Yeah, that Hawaii case.
Everyone, if you are virtual, please mute yourself.
Yeah, so I heard somebody say the Hawaii case. So yes, we'll discuss that in a little bit, County of Maui. So for now, let's just focus on the fact that waters of the United States is not defined in the statute. And that has resulted in decades of mayhem trying to define it through regulation. So why does it matter? It matters because it controls which waters EPA and the Corps can regulate. So this matters for NWPR's permits, for Section 404 permitting, and other really important protections. So the recent history of Clean Water Act regulations attempting to define waters of the US. In 2015, EPA adopted the Clean Water Rule, which redefined the term navigable waters. In 2017, then President Trump directed EPA to consider repealing that Clean Water Rule and replacing it with one adopting a different and more narrow construction of what navigable waters means. In 2019, EPA did in fact repeal the Clean Water Rule, and it reinstated pre-2015 regulations. In 2020, the EPA redefined and it called it the Navigable Waters Protection Rule, which essentially adopted Justice Scalia's test, which we'll talk about in a few minutes, despite plenty of scientific and legal evidence that narrowing the definition of navigable waters would seriously contravene Clean Water Act objectives. In 2021, President Biden directed the EPA and the Corps to reconsider. So accordingly, in 2021, actually on June 9th, the EPA noticed its intention to revise the definition of the waters of the United States. So what rule is in place now? EPA has indicated that it will regulate consistent with the pre-2015 regulatory regime. So to really understand what all this means, I'm going to talk for a few minutes about the Supreme Court case Rapinos versus United States. And this was a 2006 case. And as I said, it really sought to push around the edges of what is a navigable water, what is a water of the United States, such that it's subject to EPA's and the Corps' regulation and jurisdiction. In Rapinos, there was no definition of waters of the United States that garnered a majority opinion. Scalia wrote the plurality opinion, and he posited that in order for EPA and the Corps to exert jurisdiction, that the area they were attempting to regulate had to have a continuous surface water connection with traditionally navigable waters. Justice Kennedy wrote a concurrence. In the concurrence, he proposed an alternate test. He said that the agencies can regulate if the areas they're regulating have a significant nexus when considered in connection to the navigable waters. Now, as you can imagine, these are really fuzzy terms, and there's significant dispute about what a significant nexus even means. Some courts even will dispute whether Kennedy intended the significant nexus test to be more restrictive or less restrictive than Scalia's plurality test. And moreover, cases even within the same jurisdiction split about how to figure out which test from Rapinos controls. And they do this in a number of ways by applying a Marx analysis, but essentially it all boils down to what did the most number of judges agree with in principle, and we take that to be the controlling ruling. So there's a line of cases that is quite active right now that started shortly after the Supreme Court case in Rapinos, and those are Sackett versus EPA. So the Sackett case involved a homeowner who wanted to construct a home in an area that was zoned for the homeowner to construct the family home. they began, and actually the Sackett case line and the court docket includes some photos of what the property looked like. And those photos will be familiar to anyone in New Jersey that's driven down the turnpike and gone through the Meadowlands. And, you know, at first blush, when you look at this area, there were some pretty good visual signals, as well as signals from the soils and its proximity to a nearby lake, that these lands were wetlands that they were building their home in. So initially, the district court case, so what happened was the EPA came by, they said to Sackett, you better knock it off. You need a permit from the Corps. You can't go and fill in this area and build a house on it. Sackett sued over that jurisdictional determination that EPA had found that the land was subject to regulation, that it was waters of the United States. So this happened in Idaho in 2008. It was taken up by the Ninth Circuit in 2010. It hit the Supreme Court in 2012. It went back down to the district court in 2019. And in 2021, this year in August, the Ninth Circuit ruled again. So this, and on September 22nd, once again, a cert petition was filed in front of the Supreme Court. So why is this case so controversial? This case involves exactly the split between whether there is a controlling opinion from Rapanos and whether it should be the plurality opinion that there has to be a continuous surface water connection, or whether the significant nexus test is the controlling test. So the cert petitions that were just filed, and many petitions that were filed actually in the last 2 weeks in support of cert, essentially drive the controversy, and they elaborate on it in the following way. These homeowners have spent the last 15 years just trying to build a house in good faith in an area that at best is soggy. There's a highway that separates this area from anything that we would really traditionally consider navigable water. And jurisdictionally, this can't be something that the EPA and the Corps regulate. Because if the EPA and the Corps regulate this, then they can regulate any soggy, was the cert petition's description land, any soggy property. And while this might seem like something the Supreme Court has already dealt with, I think that there's, at least in my opinion, a fair chance that the court will take up this cert petition, because as you look across the country in the breadth of case law, and even though the EPA actually under different administrations told the Sacketts, well, we're not going to enforce this, you can go ahead and build, but the jurisdictional determination was never withdrawn. That's what the petitioners are after. So the Supreme Court is going to look at this area of the law, and what they're going to see is a complete.
No, I was just about to say there's a lot less of just like, what's going on?
Are you on, Jen?
All right, everyone, please mute
Yes, I
yourself.
just opened it up.
So the Supreme Court is likely to look at all of the courts across the country that have grappled with this and come to radically different answers about what wetlands are protected. And that's really important for a number of reasons. One is, certainly there's a pretty good argument to be made here that certainty over what is jurisdictionally regulable by EPA and Corps, that there's value in that. There's value for developers. There's value for folks who want to site new projects. It's not just projects that traditional environmentalists might oppose. It's projects that could be necessary for the clean energy transition and siting of infrastructure. Of course, the first order of siting that infrastructure would be avoiding jurisdictional and navigable waters. So in order to avoid it and protect it, there has to be some kind of robust understanding, at least within the same circuit, about what that means. So the cert petition is fairly compelling in the way it really lays out the most basic idea, which is that nobody can agree on which properties are subject to regulation. So the most important point to this series of cases is that a science-based regulatory regime could really mean that the significant nexus test is an essential test or some alternate version, right? Because just because somebody came along and built something right in the middle of a wetland, a highway, a road, something that disrupted the surface connection, clearly doesn't mean that what you do in that wetland isn't going to affect clearly jurisdictional wetlands or traditionally navigable waters. We all know it's all connected, and that actions that you take in wetlands and buffer lands, which Mike will talk about in New Jersey, how much more protective New Jersey's laws are for transition areas and things like that. Those areas are critically important to preserving water quality. So obviously the less that can be regulated, then the more that the water quality can be rapidly degraded. So that's kind of that basket of cases that relates to what will bring on EPA and court jurisdiction. The one other case in that basket that I want to mention is not a Supreme Court case, but it's the Pasquayaki tribe case versus EPA. And it was just decided in August of this year. And that's the case specifically that vacated EPA's 2020 navigable water protection rule. And the reason it vacated that rule, and the tribes who moved for it, they wanted it to be remanded to EPA with vacator, and EPA moved to remand but leave it in place. The court actually found that if they just remanded the Trump era rule to EPA, that it could risk serious environmental harm. And that's because agencies, states, folks have been documenting how many jurisdictional waters would be taken out of the federal protective ambit. And particularly in significantly arid states, the number of areas that could come out of this protection are significant. So the District of Arizona actually vacated that rule. And one of the reasons that I think that the court could take up the Sackett cert petition, even though EPA right now is in the process of trying to hash out new regulatory definitions for waters in the United States, is that it has been so controversial and it has been such a mess across the country that, you know, the argument petitioners are making to the court is that EPA is unlikely to be able to do this because they haven't done it to date. Of course, that's, you know, that's subject to a lot of different views, and we all know EPA scientists have been working really hard throughout the changes in administration to make sure that they come up with a definition that is really scientifically justifiable. So it's, in my view, this court has been taking up cases that even if agencies are trying to work through rules, the court seems just much more interventionist, that they're willing to kind of wade into these waters, no pun intended. So I'll move just really briefly to the County of Maui line of cases. And this line of cases is all about that other portion of the Clean Water Act provision, So as we talked about at the beginning, the Clean Water Act forbids any addition of pollutants from point sources to navigable waters. So we've just talked about the significant controversy about what is a navigable water because it's not defined by the statute. This one is, what does it mean to add pollutants from point sources to navigable waters? This case is all about the prepositions. And if you take a look at the case really frames it. They say this case is all about the word from. It's such a small preposition, and the Supreme Court case makes so many attempts at analogies describing what do ordinary people think about the word from. And it's from the analogies of, if you ask somebody where are they from or where have they come from, their answer might be I came off the plane. Their answer might be I came from Germany. If you are adding the turkey dripping, adding the drippings from a turkey to the stuffing, does it mean it has to come directly from the turkey? Can you catch them in a pan and then pour them from the pan into the stuffing? Believe it or not, these were all discussions that were happening in the Supreme Court opinion. So that case factually involved a county wastewater reclamation facility that was collecting sewage, partially treating it and pumping it into the ground through 4 different wells. The effluent traveled about half of a mile through the groundwater to the Pacific Ocean. So the court framed out the question to be whether the Clean Water Act requires a permit when pollutants originate from a point source, but are conveyed to the navigable water. Here, the Pacific Ocean, there's no contention about whether or not that's a navigable water, by a non-point source, which in the Maui case was groundwater. So in that case, the court established what it called the functional equivalent test. The court found that if the addition of pollutants to groundwater is the functional equivalent of a direct discharge from the point source into the navigable water, a permit is required. The court further on went on to say that there are myriad factors that a court could consider and that the agencies could consider in figuring out whether or not something's the functional equivalent. The court said time and distance are the most important. Time being, how long did it take from the time the pollutant left the point source to the time the pollutant showed up in the water. Distance is obvious. It's, in County Maui, it was half a mile. Distance could be, is it 20 miles away? And then the court went on to enumerate 7 other factors. So again, this functional equivalent test, it's not a bright line test like most other things in Clean Water Act land. Other tests that had been developed in the courts, the District of Hawaii had gone with a clearly ascertainable path test. The Ninth Circuit had gone with a fairly traceable path test. The functional equivalent test that the Supreme Court settled on, I think it falls somewhere in between those two. Fairly traceable seemed just too big because, as we know, everything is connected, all water is connected. So fairly traceable seemed too big. Clearly ascertainable seemed too narrow. And the folks who wrote the opinion in the Maui case really kind of started with the proposition that a statute ought not to be able to be evaded by some easily created loophole. And so if a pipe was up here 2 feet above a navigable water and it's traveling through the air, very few people would argue that that's not a discharge from the point source into the navigable water. What if you move that pipe back a few feet? again, really hard to see. But the biggest objection to the functional equivalency test is that it involves discretion and judgment. But again, it's really hard to imagine how you would have a bright line test that didn't involve discretion and judgment. So on remand in 2021, the court granted the plaintiff's motion for summary judgment, finding that the county of Maui had discharged tens of thousands of gallons of wastewater from the facility into the Pacific Ocean on a daily basis at a few monitored seep vents. They balanced the factors set forth by the Supreme Court, as well as an additional factor. And the court said this facility must have a NPDES permit. So the discharge from the county's injection wells into the groundwater, ultimately the ocean, was a functional equivalent of a direct discharge. The court further found it tried to protect its ruling by finding that even if it didn't consider the additional volume factor of how much wastewater was going in and limited itself to the 7 factors, it still would have been the functional equivalent. So that's one that has been disposed of on summary judgment. There was an order denying reconsideration. And it's unclear kind of where this is going to go. Other cases, other circuits are grappling with these rulings now. There's a case called Inland Empire Waterkeeper versus Corona Clay in the Ninth Circuit. And again, they vacated the district court's judgment and they remanded for the district for the further proceedings consistent with the Maui standard. So what are the common threads between the Sackett bucket of cases and the Maui bucket of cases? One of the common threads that I see is that folks arguing for narrowing the rules, saying EPA has got to narrow what the waters of the United States is, or the conveyance has to be directly into a navigable water. What they're really arguing is not that groundwater can't be protected or regulated, but there's this theme in both these lines of cases that suggests that a larger federal role will abridge the state's traditional right to regulate in these areas. So I definitely don't agree with that. And as we all know, and as Mike will talk about, the state's traditional right to regulate is not abridged by a larger federal, because the state in all of these statutes can always regulate more stringently than the federal government. So just because the federal government is protecting something doesn't really abridge the state's right to layer on additional or more stringent rules. So second point, a common thread between these was really kind of pointed out by Justice Kavanaugh in his Maui concurrence. And he linked the two cases together. He pointed really to Scalia's Rapinos opinion. And this is the point that shows how the Clean Water Act would be thwarted if passing through some kind of a non-jurisdictional conveyance, like an ephemeral stream, would allow polluters to evade permitting. So these cases all live really in the gray area of figuring out what is the right spot for regulation and how do we define these in a way that gives people certainty, but still allows the agency science-based discretion to protect our water quality. So the next kind of series, sorry,
Jen,
go
let
ahead.
me just jump in very quickly. You know,
Yeah.
it is kind of amazing that something we're going to celebrate the 50th anniversary next fall. We're still arguing over very, very basic concepts. What is a water of the United States? What is a navigable water? And that was one of the questions in the chat. I don't think that's even really defined, but my recollection is there is a line from Scalia that said, if, you know, Davy Crockett or, Lewis and Clark could put a canoe in it that's navigable. And so if it was navigable at the formation of the country, that's what we're talking about. I keep meaning to go back and find if that was actually in a case somewhere, but and it really just goes to the powers of the United States under the Commerce Clause to regulate these things. All of our environmental statutes are really under a public health or Commerce Clause protection and not a environmental protection kind of concept. So I just sort of wanted to jump in there with that.
Sure. So, and yes, there is if you could put a canoe in or float a log down it without having to take it out and put it back in. So, that's left to some portions of some waterways are considered navigable for certain purposes. There is no crystal clear definition of navigability. This has also come up in public trust doctrine cases where the concept of navigable waters over which states can have traditional public trust authority. Apologies for the dogs.
All right, so you know what, I will talk just a little briefly, for people who aren't, sort of steeped in this. New Jersey's kind of unique in that we are one of two and maybe to be three states that really regulate the whole suite of water protections, from the discharge of pollutants to the dredge and fill. We're one of the two, maybe soon to be three states that regulate that sort of dredge and fill, the discharge of dirt and impacts to waterways without having to go to the Army Corps of Engineers or EPA. In many other states, you might have to get a state permit, but you also have to get a federal permit. In New Jersey, we're a one-stop shop, which sort of makes us unique and important for state level protections as well. And if the dogs are now complying.
They are, the mail has come and gone. So thank you for that, because that's a perfect segue into talking about Clean Water Act Section 401 certification. This is critically important tool in almost every state. As Mike said, in New Jersey, it certainly is an important tool, but New Jersey, because it is at the moment one of two delegated states, it also has the additional ability in most areas of New Jersey, excluding the Hackensack Meadowlands, to layer on more stringent wetlands protection rules. And in New Jersey, typically, you get a 401 water quality certification if you can pass the state's implementation of the Section 404 wetlands rules. And that's, generalizing it, but that's basically the case. So Section 401 has operated largely through Supreme Court interpretation of that statutory provision. And one of the most important cases was PUD #1 case. And what that case really found was that states could look at myriad, under 401 could look at myriad factors that it believed would affect state water quality in deciding whether or not to grant certification for those projects that required Section 401 certification. President Trump advanced a Section 401 rule during his administration. That rule made a variety of substantive changes to EPA's procedures for implementing 401. It narrowed the scope of certification to really restrict the state's ability to protect water quality by narrowing it down to certain statutory water quality factors. Again, that was a significant narrowing because states in their 401 programs were looking at lots and lots of factors that applied to the project writ large, as opposed to just the very narrow physical alteration that triggered the 401 certification requirement. It also, Trump's 401 rule also authorized EPA to establish a time to certify the authority to certify a request. So it also put EPA really more in charge of determining whether or not a state's 401 was timely when the application was complete. That would trigger the statutory time trigger, and also whether or not the state's denial complied with the rule's procedural requirements, and to deem the certification process waived if not. So fairly rapidly, with the change in administration, EPA stated its intent to promulgate a new certification rule. It did that on June 6, 2021. And for a number of procedural reasons, the earliest EPA would really be able to promulgate a revised rule would be around the spring of 2023. So very recently, on October 21st, the Northern District of California, in ongoing litigation brought by many states and other parties about this Clean Water Act rulemaking, vacated the Trump era 401 rule. Again, very similar to what happened in the context we've just discussed, EPA moved to remand the proceedings without vacator. The court, in fact, vacated the rule and remanded to the agency. One active question in that litigation, which is kind of a split in a lot of the courts, is, did the court have to reach the merits of the rule in order to be able to vacate it and remand? And the court found that vacator is an equitable remedy, and that the agency itself requested remand. The Administrative Procedure Act doesn't preclude the court from exercising equitable jurisdiction, and that the Administrative Procedure Act doesn't preclude granting vacator without a decision on the merits. So the court never reached the merits of the Clean Water Act rule itself. It vacated it. And it did it for a number of reasons, but primarily because it found the rule antithetical to the Supreme Court case in PUD number 1, which found that the Clean Water Act conferred on the states the power to consider all state actions related to water quality in imposing the conditions or denying Section 401 certificates. So that is, again, a really bright line to things that states traditionally are responsible for regulating under their police power and protecting health and safety. And as Mike mentioned, it's a different source of authority under which these federal regulations are born. Those are born out of Congress's Commerce Clause jurisdiction and ability to regulate, and almost every one of these statutes we're talking about grows out of the Commerce Clause of the Constitution. So state environmental laws grow out of a very different source of authority.
And, I'm going to jump in again. Just understand the sort of dissonance. You have the Navigable Waters Protection Rule and this Trump's 401 rule. In the Navigable Waters Rule, Trump, the EPA at the time said, well, states have primary responsibility for waters. They should have the right to say what they want to say. In the 401 rule says, states don't know what they're doing. We need to rein them in, and they don't have the authority to regulate waters in their own jurisdiction. I mean, it was very hard to read both rules in succession and understand how they came to the same place. But they did. And, the 401 was in the statute recognizing the state's primary role to protect waters within their jurisdiction, within their, the borders. And what the 401 rule that Trump proposed was, if you're not doing a direct discharge into our waterway, you don't have a say. And if you think about it just from a real perspective, we all know if you rip out all the trees and vegetation along our waterway, you're going to have an impact to that waterway. But under the 401 rule that was under the prior administration, the state couldn't say no to a project because it may not result in a direct discharge into that waterway. So really trampling on states' rights and states' authority. At the same time, they're saying states should be trusted to regulate their own waters. Still makes my head spin. Sorry. Needed to add that editorial.
Yeah, I think that that's really important, and that kind of brings us to why are we talking about pipeline cases here at a watershed conference? And the states finally stepping up and saying no under Clean Water Act Section 401 to a number of fossil fuel infrastructure projects was really the genesis of the Trump 401 rule. So although states in denying 401 certification to those projects did not predicate or rest the denial on climate grounds or other grounds like that, their exercise of their absolute right to deny predicated on the fact that these enormous linear pipeline, gas pipeline projects would disrupt state water quality with crossing pristine streams, as Mike said, clearing rights of way, all of the other ground disturbance involved in them. So it had been exceedingly rare for states to ever say no under Section 401. All of a sudden, a couple states said no, and just a couple states were still granting 401 certification for most, if not all, fossil fuel infrastructure projects. But the second states began to say no, that's what gave rise to the 401 rule. So I'm not going to talk at length about the FERC jurisdictional gas interstate pipeline projects, but just to note that those projects and our ability to attack and challenge those projects has kind of grown out of two different bases. One is it's grown out of states' willingness to actually understand, and really on the backs of environmental advocates who have put data forward about the dangers of horizontal directional drilling, about the dangers to our waterways. And simultaneously, the fact that advocates have raised the profile of whether or not this fossil fuel infrastructure was needed. So those twin grounds, the environmental ground and really educating state environmental agencies, other state regulatory agencies about their power under Section 401, and simultaneously really getting steeped in the economics of these projects and trying to understand whether, in fact, there is a need for this additional gas capacity. And one thing that cuts across Jordan Cove, Spire versus the Spire pipeline and the PennEast pipeline is the fact that these are affiliate transactions, self-dealing pipelines where the shippers are the affiliates of the pipeline builders. And so for all of these projects on an economic basis, this gas was not actually needed in the regions that the pipelines were serving. From an environmental basis, these projects have the potential, as we saw with Mariner East, to cause enormous environmental damage. So those kind of twin bases have really impacted the landscape of how courts are looking at and really increasingly questioning the Federal Energy Regulatory Commission's process for how it is going about looking at and giving authorization for these projects. And then the last thing that I'll just really briefly mention is what SCOTUS did at the end of last week. It took up questions from 4 different cases that really raise the specter of whether or not they're prepared to walk back EPA's ability to regulate greenhouse gas emissions. Everybody was really surprised, chagrined, disappointed that the court took this up at a time, again, when the EPA is very hard at work writing regulations that pertain to these facilities and how to regulate the emissions from them. So if the court decides on a narrow basis, the harm from its review will be limited. A lot of legal scholars fear that the court will reach either the non-delegation doctrine and try to revive it, or the major questions doctrine, both of which really seek to either limit Congress's ability to delegate through statute these questions to the technical agencies to administer, or whether the technical agencies have sought to regulate in an area where there's really a major question, and our very dysfunctional Congress would be called upon to rewrite the statute with more specificity. So, you know, on that note, I just want to turn it back over to Mike, because really, in my mind, what is going on at SCOTUS and what we're really seeing out at the federal level make crystal clear that state protection, state regulation, state statutory authority over waters, over air, are going to be our best chance at really protecting these waters and averting climate change. And so action at the state level really can't be underestimated, just the importance of that.
All right, thank you, Jen. For once again, I screwed up my slide somehow. Yeah, I mean, right now we're seeing this shift, as Jen mentioned, in the Supreme Court and the federal courts, where there used to be a huge amount of deference to the agency and its interpretations, where the statutes didn't speak clearly. And now it's sort of, well, if the statute doesn't speak clearly, Congress didn't intend to do it, and therefore the agencies can't make law that they weren't directly, delegated to do. And in New Jersey, we are lucky in that we have some of the strongest protections in the country, at least on paper. I would argue with my friend Vince Mazzei whether we actually implement those sometimes. But, for example, as I mentioned, we're one of 2 states that have that dredge and fill permit, where you don't go to the Army Corps of Engineers, you come to New Jersey. Michigan, I think, is the other one. Florida is looking to get it, and that kind of scares me a little bit. And I think Texas may be looking to do it too. But in New Jersey, all waters are regulated. So, that is very different than the, sort of Clean Water Act, only navigable waters are protected. And in New Jersey, all waters. There's some discussion going on how you sort of determine what a water is. Again, it's amazing, 50 years and we still don't know what a stream or a creek is and how to protect it. One of the biggest problems in our rules is, while all waters are regulated, that doesn't mean all waters get all of the protections. I may need to get what's called an Egypti's permit, a discharge permit, to discharge into like a little tiny stream, but it may not get what's called a riparian zone, a buffer. And there are regulations in our rules that say riparian zones, that buffer, only applies to waters that have a defined bed and bank. If they receive water from less than 50 acres. And one of the big issues with that is, well, if you have a headwater, the start of a stream, there's not 50 acres draining into it. It might be only a couple acres. And if you don't protect the headwaters, how do you expect the bottom of that stream to be clean and healthy? I believe the NJPAC rules may change that, so we actually get those protections, because you can pollute a water not just by putting something directly into it, or if County Maui went the wrong way 2 feet away from it, but you can do it by developing around it. So that's going on. So between our freshwater wetlands rules and our freshwater flood hazard rules, we are really regulating a full breadth of things. There's 63 different ways to build in a riparian zone under the current rules, which Vince mentioned yesterday, if you were on the NJPAC rules, may change a bit going forward. So there's a couple of things I wanted to talk to, case-wise. There was one in particular case, and it's sort of a practical issue. When DEP issues a permit that you don't like, how do you challenge that permit? And there are 2 ways to do it. One, you run to the appellate division, the courts. You don't go to the trial courts, but you go to the appellate and you file an appeal, a notice of appeal. The other way is to file what's called an adjudicatory hearing at DEP. So you're asking the agency to reconsider its decision. And there is, administrative law judges that deal with that. And there's this big, long case that sort of brought up who could file that appeal and where. And from a practitioner perspective, this is extremely important. Oops. So in that case, neighbors challenged what's called a CAFRA permit and a freshwater wetlands protection permit, because they didn't like the fact that DEP issued a permit to build several hundred housing units and clubhouses and literally adjacent to them. They filed that appeal within 45 days with DEP, so they asked for that administrative hearing. The DEP commissioner, which is not unheard of, said, no, we made the right decision and I'm not changing that. And they denied it. And so then the challengers went to the appellate division. And the problem is that you have to file all appeals within 45 days. The permit that they challenged was issued more than 45 days before they went to court. They only had, at that point, the only thing they could challenge was the commissioner's decision to deny their hearing. And so really what it came down to was, under the Administrative Procedures Act, who has to file where? If I'm the property owner who wants the permit, I certainly have the right to appeal to the administrative agency. Just about everyone else, anyone who's not an applicant, who is not a state agency, is a third person. If I had an easement on that property, or maybe if I had a property right to purchase that property, I might be someone who had a particularized property interest, and I could then get administrative hearing. Or if there was a statute that said, but the freshwater wetlands and the CAFRA statute didn't give those rights. So the appellate court said, the only thing you can challenge is the commissioner's decision not to give you a hearing, because you're out of time to actually challenge the actual merits of the permit. And the commissioner was well within their rights, because you had no rights to go to DEP and challenge. So that's sort of, you may lose because you went to the wrong house. And to even understand just a little more, DEP originally denied the permits And the ones that they issued was because of a challenge by the applicant, and there was a settlement agreement. So there may have been merits to challenge it, but because they went to the wrong house, so to speak, the wrong forum, they didn't get to do it. All right. And one of those areas where New Jersey is in the forefront of environmental protection. I'm sorry.
Just have a question. We work for the court. We dealt with appeals all the time. And we would typically let the first process play out and start the clock after that was done. So say somebody did an appeal, you know, it said you had to
Yep.
go, so
So-
your 45 days wouldn't start ticking until your motion for reconsideration was denied. And they were going back and forth, but most of the judges I dealt with had a sort of very open understanding if somebody filed in the wrong place. The theory is everybody should get their, if they made a good faith effort, not like they come in 5 years later, but
Yeah.
if
So-
they made a good faith effort, I'm surprised that the appellate didn't decide to take it up outside of the time.
So the question really was, you know, don't the courts have sort of leeway and equity to expand that time?
Right.
And, you know, if you filed the appeal in the wrong county, yes, the courts have a lot more leeway. This is something in the Administrative Procedures Act, a statute, where it sort is the roadmap of where you file. And even though courts do have sort of that leeway, they don't always have to recognize it. I mean, there is tons of cases of when you filed out of time, but and how to sort of, you know, weigh the factors. But this is fairly clear and sort of, you know, you have to decide whether you have that particularized property interest if you are a neighbor or a adjoining property. Best bet is if you have any question, file in both places at the same time. Just a practical perspective. So in September of last year, the environmental justice law was signed. Again, this is one of those areas where New Jersey is in the forefront. It created defined what's called an overburdened community. And since we are running very short in time, I'm going to run really quickly through it, and they defined that. They have a map, so if you want to look at where those communities are in New Jersey, and you can even, there is a GeoWeb layer, so you can sort of go in farther and look at it. So in these overburdened communities, applicants have to do more when they file for a DEP permit than they would in, say, rural Sussex County. Not that you can't have an overburdened community in rural areas, but, and they have to create what's called an environmental justice impact statement, which looks at, and it's sort of NEPA-like, assess the environmental and public health stressors that community, that overburdened community is experiencing, and how this project will add or subtract or cumulatively impact that. That statement then gets sent to the DEP, gets sent to the municipality. There are outreach requirements on the applicant so that the community actually know this is happening. The applicant has to have a public hearing where the applicant is bringing the community in, explaining to the community what's going on, and getting feedback. The DEP, once they promulgate regulations, so this is a statute, there are no rules yet, can deny a permit if it finds certain things. So if you are going to contribute or cause an adverse cumulative environmental or public health stressor in that community, the DEP can deny that permit. You can meet all the other requirements of that permit. You know, for example, in the flood hazard rules, I'm outside the 50-foot riparian zone. I'm not discharging pollutants into that waterway. My stormwater rules are complied with. I could comply with the letter of all of the individual permit requirements, but if I'm going to have a cumulative impact to that community, DEP can deny that permit, which sounds great. And it is. It's not all facilities. So a warehouse that's having hundreds and hundreds of trucks doesn't necessarily meet that requirement. You have to be a major air source. You have to be a resource recovery facility, an incinerator, some of the really nasty stuff that you think of. If you meet that definition of facility, you fall under those requirements. And that really provides a lot of strength to these overburdened communities that are already suffering severe impacts and don't necessarily have a voice and the ability to say no. One thing to know is all of that is operational when DEP proposes regulations. DEP hasn't proposed regulations yet. So what Commissioner LaTourette did was issue an administrative order that, in essence, put those regulations in place right now, giving DEP time to propose and adopt those regulations, but providing protections to that community today. So a lot of what's in the law and what would be in the regulations is now in place. The warehouse bill. This is one of those areas where, wow, warehouses have been piling up in New Jersey, coming into communities that one probably would say shouldn't necessarily come in. And the real sort of interesting aspect, and this is sort of, it's a rallying cry, but I think it's missing a sort of bigger problem. So Community X wants a warehouse. They propose it. They're going to put it on the outskirts of their town, because the outskirts of the town, they only have to go through a couple minor small roads, and then they get to a highway. Most of those small roads are not in my town. They're in the neighboring town. The neighboring town has no say right now. They can show up to a planning board hearing, but they have no additional rights than anyone else. They may never even know it. That neighboring town isn't 200 feet away from the property. They never get noticed. So this warehouse bill, which is sponsored by Senator Sweeney, which is a whole other issue. We'll talk about that tomorrow. Which I had expected to be passed this year in lame duck, requires notice to the neighboring town, allows the town to object, and then provides a mechanism for either the county planning board or the state planning commission to have a hearing. And also requires the host municipality, again, to develop almost like a NEPA-like impact statement, a regional economic and land use impact. How is this going to affect not only my town, but the neighboring towns from an economic and land use perspective? The municipality has to prepare that report, has to provide it to the neighboring towns and the whatever body is going to have that hearing by the time of the hearing, which is probably 10 days or 20 days or 30 days too late. It should probably be ahead of time. And also importantly, it removes sort of the capture problem of having the applicant pay for it, but they don't get to prepare it. Because if you've ever been to a planning board and had to have a traffic engineer talk, traffic engineers never find a problem. And if it was a problem, it wasn't because of me, it always existed, and you don't have to make me do anything. And then the county planning board or the state planning commission, depending on certain circumstances, gets to decide. Yes, that application can happen without substantial detriment to the general welfare of the region and other municipalities. without substantial detriment to the economic and fiscal aspect of the neighboring municipalities and region, and doesn't impact the master plan and zoning of an adjacent municipality. So think about it as town X wants the warehouse, but I want to put it as far at the edge of my property as my town as possible, so my community doesn't have to have these trucks come through. Take the back roads to the state highway, and it's great. Right next to this warehouse is municipality Y, which has their schools, they have their residential area. And all these trucks now have to go through that. Now we have to look at that. And I think, as I said, this warehouse thing is sort of like the spotlight, the canary in the coal mine, but it's in everything we do from a land use perspective. The impacts we have are regional. Think of it from a traffic, from an air emissions, from a stormwater perspective, flooding. If I put 100% impervious cover on my property, which my zoning allows, right adjacent to a neighboring town, they get the flooding, not me. It's okay with me. So I'm really hopeful this is a start of a conversation of more of a regional approach. And as I said, this was a bill that's been working through legislature. Senator Sweeney had sponsored it. I was expecting it to pass in lame duck. So between Tuesday and at the end of, I guess, mid-January when the new session starts, given the way that election went, I'm not so sure what happens now, but we will see. And then the forever chemicals. Most of you, hopefully everyone has heard of PFOS and PFOA, Teflon, stain resistant carpets. It's a great chemical. The problem is it's water soluble and never, ever, ever goes away. There's a map on the right of all the sites in New Jersey that PFOA and PFOS have been detected. In the middle is a national map. And then in recent news, just a week or two ago, a Middlesex County water plant detected it in their water supply, and it has, caused a lot of problems. In New Jersey, we again are in the forefront. So last year we adopted the most stringent, I believe, standard in the country for these chemicals in our drinking water, in our surface water, in our groundwater. Because you remember, these are forever chemicals. Once they get in, they ain't coming out. And by adopting these things, we are requiring water treatment plants to test for it. And if they detect at these levels, treat so it is removed and cleaned. We also required it to be tested in wells. So if you have a well on your property, the Private Well Testing Act now requires when you go to sell to test for it. Private Well Testing Act doesn't require you to remediate, just to test. The reality is, if you're selling and that person's getting a mortgage, if you don't remediate, the buyer doesn't get the mortgage because the mortgage company is not going to give you money to buy a house that you can't drink the water from. So you're remediating, but not required. And there's actually legislation going toward trying to fix that as well. And so New Jersey last year adopted all of these. States and the EPA is sort of moving toward to catch up. So this is some of the things EPA has done in the last 10 months or so, and will continue forward. They set last year a health advisory issue at 70 micrograms per liter, which is quite a bit higher than the 13 and 14 that the New Jersey state did. And that's just a health advisory. That doesn't have any regulatory or legal impacts. That's just EPA saying, we think above that level, you should look at it and think about it. But wastewater treatment plants, water treatment plants do not have to do anything. And that was a very, very quick rundown on some of things going on at the state. If you were at the session yesterday at the NJPAC rules, a massive rewrite of our flood hazard, freshwater wetland, coastal rules, and storm. Not as much of a massive rewrite of the stormwater rules will be coming out sometime early next year. If you weren't able to make the NJPAC rule, that was recorded and will be provided, but really provides a rework. So for example, are we now going to start protecting headwaters where we have not in the past? Are we going to treat waters differently if they're impaired and not allow certain things to occur that might meet standards otherwise? I certainly hope so. Are we going to redefine what a storm is? The 2-year storm is 3.3 inches in Mercer County. That is based upon 106 years of data that ended in 2006. We're getting a lot more water. So my understanding is those rules are going to update that information. So we're actually accommodating what's occurring now and what will happen in the future. That was very quick. I apologize. I apologize for starting a little bit late. Do people have any questions?
I have one question. What would PennEast say? But the Supreme Court, my understanding is the Supreme Court decision gave them the authority to basically take public land. Is there any way that could be undone, or is that now federal law?
Because that makes me too depressed that I agreed with Justice Amy Coney Barrett. I can't even say her name. It makes me so upset. I'm gonna leave that one to Jen. Did you hear the question, Jen? What does the PennEast Supreme Court decision really mean for private companies taking state land?
I don't think really means very much, because until PennEast, there had only really been 1 or 2 other incidences of states refusing to allow a condemnation to proceed. So I do think that the potential ramifications are very limited. And I think you can really kind of see that from the fact that the PennEast project is not moving forward on other grounds. There are many, many, many grounds to address these projects, and really increasingly going forward, our hope is that the Federal Energy Regulatory Commission will be taking into account state greenhouse gas reduction policies and other things like that, which will really reduce the importance of a state having to go to the mat and saying, you can't take this property for this project. So as these projects fail structurally because of self-dealing, or because state and utilities are needing to make net zero commitments, I think the potential ramifications of the Supreme Court decision really kind of decrease. It was not a power that states often exercised. And so it did foreclose that as a potential route, but it was a limited route to begin with.
New Jersey didn't exercise it very frequently. They, exercised that right. I still think it's a right in PennEast, but at the same time, they were allowing other projects to go forward. So very bad decision, hopefully very limited impacts, especially if the Biden administration comes out with strong 401 rules. Yeah. Any other questions? Give it another second to see.
I guess I have a quick question.
Sure.
I guess what's going on with Middlesex around the PFOS? I read that they were trying to say the water was okay. Anyway.
Yeah.
I just hadn't gotten into that.
Yeah, I don't know exactly. I think I've seen the same things in the news. So the the questioner asked what was going on with the Middlesex contamination of the PFOS and PFOA. I think Middlesex County has hired their own experts to figure out what this really means and what should be done, because the water company, a private entity, says it's, I'm going to put on my advocate hat for a second and said, it's just bureaucratic red tape. It doesn't really mean anything. They just lowered the standards. It's still safe. I've heard that in other contexts from water purveyors. DEP says when you reach those thresholds, you are having a health impact and the company needs to remediate and fix it and install treatment. We all know that doesn't happen overnight and takes time. So the question is really what happens in the meantime. The water company, I believe, said you don't need bottled water. You don't need a special filter. You could do it if you want. You're fine. We're fixing it and we should have a treatment plant in place. I think it's in 2023. Like the people in Flint and other places in this country, where you drink contaminated water, whether it's lead, PFOA, or PFOS, or that's a little comfort. But I don't know, other than the county hiring their own experts to give them recommendations, what's going on. And hopefully, it gets fixed. But you can treat for it. But the better thing is let's stop using these chemicals and stop getting it in our drinking water. Question in the back.
The Environmental Rights Amendment passed in New York State a few days ago, and I'm really stopped us from being able to get it on the ballot. But if we had it on the ballot, would that be a significant stop some of these projects?
So the question is whether the Environmental Rights Act, and I think what you're talking about is the Green Amendment. Yeah. So there is a movement here in New Jersey, and it's occurring in several states, to pass a constitutional amendment to guarantee that not only current generations, but future generations have the right to a clean air, clean water, clean environment. That would have definitely been a tool. It is a tool to use to help deal with cumulative impacts and to address it. It's on the books, I think, in several states, and just recently over the last several years in some part to the Delaware River Keeper Network. And Pennsylvania really has come back up to forefront. Again, New Jersey has some of the strongest regulations and statutes on the books. Sometimes if it's on the books and you don't enforce it, doesn't matter. But it definitely would be an additional tool to help us deal with cumulative impacts to communities that are already under stress. The environmental justice law is a really, really strong step in that direction. All right. Any other questions? I am not seeing any in the chat. So with that, Jennifer, thank you very much. I always get to learn something when I hear you talk. I appreciate the audience, both virtual and in person. And so the next step is lunch for those people who are here, those people on the virtual world. If you want to go lunch, that's up to you. We reconvene at 1:30 for sessions. Thank you very much again. Have a good day. And Jen, thank you.
Thanks, everyone.